The rule of law and economic progress. The challenge of creating independent and efficient regulatory mechanism. As rightly said by our previous chair of this session, Mr. Lalit Bhasin, that this session is an extension of the previous session, so this topic needs no further introduction. May I request Mr. Shankar Das, Vice President, Bar Association of India, to kindly take over.
Thank you, Rachna. Please take your seats. Ladies and gentlemen, we go on to a second part of the subject, which was the subject matter of discussion this morning, which is the rule of law and economic progress. I have, as you can see, a very distinguished panel, but I sad to say that one very distinguished invitee and member, Mr. Subramaniam, T.S.R. Subramaniam, a man of high eminence, who was our cabinet secretary for quite some time, and probably he unfortunately cannot attend because he had a fall, and I'm told, a fracture, so he's hardly able to move. So we'll miss him, particularly because he, I'm sure, had seen both the regulatory mechanism functioning when it used to be part of governance or government departments, as well as its liberalization and the creation of more independent bodies later on. I don't really have to introduce the members of the panel. Prashant Kumar, everyone knows who's organizing this whole thing, which is why I'm here. And Mr. Vaidyanathan, a very eminent senior lawyer, senior counsel, who's known extremely well, not just in the Supreme Court, but around the world, as a person involved in international disputes. And Mr. Krishnan Venugopal, who, again, a Supreme Court lawyer, and it's so very nice to have someone so much younger than the rest of the panel, from whom, frankly, I expect a very positive analysis as well as perspectives for the future of the regulatory mechanisms that exist and what might be done or what might happen in terms of any improvements in them and their effectiveness. And as far as the subject itself is concerned, I have very little to say because frankly, I find it difficult to fully, I haven't had the time to study it as much as I would have liked to because the subject really is the rule of law and economic progress. And then the word used is the challenge of creating independent and efficient regulatory management mechanisms. So what the subject suggests is that there have been or are challenges to the rule of law from the regulatory mechanisms as it was or as it exists today. I have a very brief opinion on that, which is that I think the challenges to the rule of law were much more serious when the regulatory mechanism was run by government departments for a long time, and the courts used to be full of Article 14 to 26 petitions, as well as Article 32 petitions, and the court's time used to be taken with challenges as violative of the Constitution in the higher courts. However, since the creation of the expert bodies, I suppose one can call them, as regulatory bodies, my own assessment of it and whatever I've read about them and have some experience of them has been that because they are bodies full of experts, or rather mainly experts in that particular area, things move very much faster. And quite what is remarkable is their disposal rate as compared to what the disposal of any disputes or even any regulatory aspects used to be when these were part of governance. So I really don't have anything more to say except that I see the system working well, and I'm going to hope that the other speakers will analyze them. One difference, perhaps, that I would like to introduce this afternoon is that we heard Mr. Naganan this morning a brilliant exposition of the actual details of how the system has evolved and how it works. So I have requested him to remain in the hall, and in case anybody from the audience has questions, which he said he would be very happy to answer. Mr. Vaidyanathan also has suggested that what he would like to do is to make a few opening remarks, but that thereafter he would rather answer questions so that it becomes more of an interactive session rather than speeches mostly from the dais. With that, Mr. Krishnan has taken on the job of the keynote speaker for us today. So he will begin today, soon after my co-chair has given his views and said what he thinks in relation to this particular topic. He'll be followed by Mr. Krishnan and then Mr. Vaidyanathan. And that's the way we'll go. So may I request my colleague and my very distinguished co-chairperson, or chairman, as they say, to introduce the topic.
Thank you, Mr. Shankar Das. He is being one of our most elder statesmen in the Bar Association of India. And from the time I have joined, not only he has encouraged, he has never missed an opportunity to pull my legs as well. So today also, he seems to be doing that. Friends, what Mr. Shankar Das has already spoken, and moreover we have two very, very distinguished panelists who way I look at it and the way the topic is structured. Those nuances are that, as we heard from Mr. Naganan, who is again a very, very experienced practitioner on the bodies which are called regulatory bodies and in this area of law. But what is there at the front end and what we are experiencing is certainly an improvement in the system earlier. What Mr. Shankar Das said, where the government departments were taking decisions and now some kind of independence has been infused. But that was so because most of our systems were controlled by the state itself. It is the public sector enterprises which dominated major areas of economic activity. But when, after liberalization, we thought of involving private sector and even the foreign investment in a big way, there was no way nobody would have even looked at it and start working unless until we created an independent regulatory mechanism. Because the PSUs continued to have a hold, the state continued to have a role to play in the same area of economic activity, and everybody had natural apprehensions that why they should come forward and why they should make investments unless until the regulatory sectors are put in place. But then, if we look at the larger picture which emerges, is that when a controlled economy makes a move, makes a transition towards a liberalized economy, there are so many factors which intervene because the economy was structured such that there were very few formidable players with enough capital and resources in the field who could enter these areas which were so-called being liberalized. Areas like telecom, areas like which depended on using or optimizing the use of natural resources, and other areas of economic activity. So with a very limited group of players there in the field who dominated economic activity besides the state, the challenge of creating regulatory framework was even more formidable. Because as you know, that those who are interested in maximizing economic activity and who have a large scale, they also are very, very adept, and because they were the ones adept even at the time of controlled economy in working out their ways and having their say. So when the regulatory systems have been put in place, there also somehow this dominance of a very subtle kind of lobbying, which has ensured that these regulatory institutions are manned mostly by the retired bureaucrats and the personnel who will facilitate carrying out the activities or regulating the sector in a manner that may tend to to protect and promote interests of a few dominating the field. Whereas regulation means that regulator looks independently at a given sector and devises the entire framework of policy, how to promote that sector to maximize the gains for the nation, for the consumer and public as a whole, and on the other hand, laying down and seeing the rules being played out in a fair and efficient manner for that sector to grow. So the question which we are trying to raise here is that some of the things which we have now found in terms of lot of grievances, even allegations of corruption and all, whether that can at some stage be attributed also to our failure to create really robust and independent regulatory institutions, not just the nut bolts of working them, some disputes coming in front of them, the lawyer versus non-lawyer debate, the judges versus non-judges debate. The question is whether we have consciously tried to create a system of very robust, independent-minded people who look at the country and not at the narrow interests, not being the facilitators of certain way the policy is to be devised. Because one other fallout of the regulatory institutions is that as we may criticize the things were in the hands of the government, there was a lot of oversight through legislation, through the legislatures. Policy being made was before the parliament. It was open, it was being debated. But now everything is given to the specialized regulatory agencies to devise the policy. And it has receded from the public gaze as well through the legislative parliament and all. So this is the broad theme with which we thought that we may also look at the evolution of the regulatory mechanism in the country. And with these few remarks, I will request the chair to conduct the session further. Thank you.
Thank you very much, Prashant. I think you raised a very, very important point, and I'm hoping that our subsequent speakers, should they wish to, comment on this aspect, has the fact that the regulatory mechanisms, as we see them today, are also, because they are manned by either retired bureaucrats or transferred bureaucrats, do they, in their experience, find that, apart from the fact that their duty is to implement the law that in the area in which they are the experts, whether they sense a kind of a bureaucratic approach which is of the same genre or kind as we used to have earlier, or whether the application of mind is much more independent or not. And that's one aspect in any case. And then what is it that makes it possible for them to decide issues so much more quickly? In other words, the rate of disposal, as I say, is so much faster than it ever was, even in the courts, or for that matter, even when it was something that was being dealt with by departments. So let's start now with our keynote speaker, Mr. Krishnan Venugopal, my young friend, who carries this responsibility of giving us the most positive approach. Thank you, Krishnan. Thank you.
Mr. Shankar Das, Mr. Prashant Kumar, Mr. Vaidyanathan, ladies and gentlemen, I am not so sure that I am the best qualified person to be giving the keynote speech today. Frankly, I was under the impression I would be the last speaker of this afternoon, so I hadn't quite prepared enough to give you a talk of any great depth on the subject. But I'll try to give it my best shot. If we look at the beginnings of what today is known as the regulatory state, it really came in the 1930s when Franklin Delano Roosevelt, the President of the United States, was tasked with the responsibility of bringing that country out of the Great Depression. Today, as Mr. Prashant Kumar has emphasized, it's all about bringing in the market. But in those days, when regulation first came in, it was in the context of the New Deal, where there was a recognition that the laissez-faire of the previous era and the great robber barons of the United States would have to be subjected to more state involvement in the economy and more regulation. In contrast, if you look at the beginnings of the regulatory state in the United Kingdom or in India, it really was brought in at a time when the state was trying to back out from intense involvement in every sphere of economic activity. If you go back to 1956 and the then industrial policy resolution, the state was supposed to be controlling the commanding heights of the economy. It was not just a question of government regulation. Government was, in effect, going to be the backbone of the economy. As Mr. Prashant Kumar has pointed out, since he's a friend of mine from now on, I'm just going to refer to him as Prashant. As Prashant has pointed out, in 1991, under the extremely wise and capable leadership of Narasimha Rao, the union government decided for the first time that it would follow the same path as many other previously socialist economies and allow the state to recede from involvement in the economy. The most important obstacle to this was that incumbent state monopolies controlled vast swaths of the economy. In order to allow private players to enter the market and to allow them to survive in the face of these huge monopolies, you also needed independent regulators. So if you look at the sequencing, part one of the reforms of 1991 was that you allowed private enterprise into areas previously controlled by the economy. And part two was to start setting up regulators, independent regulators, so that ministries that were previously involved intimately with PSUs would not be controlling the rules of the game. So that's the basis on which you had the notion of independent regulators being introduced into our constitutional and economic system. Again, going back to the United States, one important aspect of regulation by independent regulators is that they are involved in all three aspects or functions of the state. The traditional separation of powers doctrine no longer applies to them. They discharge legislative, administrative, as well as quasi-judicial functions as part of their remit. Therefore, in most modern day statutes in India providing for independent regulators, you find they make rules, they make regulations. Thereafter, they implement those rules and regulations, and if there are disputes, they adjudicate them as well. This is why in the United States, when Roosevelt set up the Brownlow Committee to assess the functioning of these independent regulators, they became known as the headless fourth branch of government. You couldn't classify them as fish or fowl. They discharged so many different types of functions. And if you look at the rule of law in India today, that's one of the fundamental problems that our courts have had to confront, not very successfully, if I may say so. How do you deal with regulators in terms of classification? Do you classify them as legislative? Do you classify them as administrative? Or do you classify them as quasi-judicial? Under our system, depending on how you classify them, there are different rules, procedural rules, applicable to their functioning and different standards on which you will assess whether to set aside whatever action that they have taken. Having said that, I would also like to point out that an important lacuna in our legal system, in our judicial system, in dealing with independent regulators is that regulators make policy. They implement policy. In order to be able to assess whether they're doing their jobs, you need to understand and apply policy. But our judicial system, which under our constitution ultimately must decide on the validity of anything done by any state agency, does not have the necessary policy expertise in most cases to be able to assess properly the policy element when judging or adjudicating the validity of the actions taken by regulators. So this goes to some extent to the issue of efficiency of regulation. If you have regulators trying to implement policy, but ultimately the law that is made applicable to them is based upon arcane judicial rules that don't factor in policy, you're not going to get a very efficient outcome from a market standpoint.